Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in the state of Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. You know, a lot of times we try to make videos that are topic sensitive to issues raised by our viewing audience. I'd like to address an issue today that was raised, and the issue verbatim says, "Can I stop my ex's new spouse from seeing my child?" End quote. So what does that mean? There's a divorce, let's say, there's a child, a product of the marriage, and then a remarriage. And this person is saying, can I stop the new mother, let's say the stepmother or the stepfather, can I stop that person from seeing my child? Well, question number one, any lawyer is going to ask is, why would you want to do that? I mean, why would you want to create such a difficult home life for your child in the context of that? I will tell you, though, that there could be reasons. I mean, you could initially start out, everything's okay, and all of a sudden you want to stop the new spouse from having access to your child because you learn the new spouse is a drug addict, you learn that they consort with known felons, these kinds of things. It could come up. But you're going to have a compelling reason. If you have a compelling reason, like the one that I just enumerated, you can file a motion with the court, or you can do what we call moving the court. Moving the court means file a motion with the court. And you tell the court, look, man, I got a problem here, Judge. I mean, I want to get along with everybody, but the fact of the matter is, my ex married a guy who's addicted to heroin. And it's all over the house, and I don't want my child exposed to it, or whatever it is. But I will tell you this. In line with the way the question is worded to us, it seems more that there's a problem between the biological parent and new spouse. That's what it seems like to me. And if the court gets wind of the fact that the reason for the motion is not to promote the best interest of the child, but is rather a function of one's jealousy that someone else had moved on, someone else remarried, if that's what the court thinks that this is, expect not only will your motion be denied, expect to get a lecture. Expect to be told by the court to grow up. Expect that the court is not going to have a lot of sympathy and you're not going to get much traction with it. And the court is not going to be happy that you put your child in the middle of your own problem. The court's going to tell you you have a problem with the new ex, go solve it. But don't bring your kid in the middle. Having said that, again, let's not be unmindful of the fact that there could be a compelling reason to keep the new spouse away from the child. Now, what if the problem is, it's not that they're a drug addict and it's not necessarily your thing, but the child is having a problem adjusting to this new spouse? Well, that's not a reason for the court to say, okay, no parenting time, I don't want the child around there. The court's not going to do that. That may be a reason for some family counseling. That may be a reason why there may be an adjustment period. There may be things that go on. It's the child step-parent relationship is the subject of books and movies and is notoriously poor. And we see that all the time. Sometimes it's better, sometimes it's worse. It's probably not a reason, though, to tell somebody, well, if your new husband is around, your kid can't be there. It's not likely that the court is going to take that position unless the court feels there's an unusual threat to the child. If you have any questions about that, reach out, and we'll be glad to help you out.